Good morning. I appear on behalf of my client, Pivot Legal Society, which advocates on behalf of the residents of the downtown east side of Vancouver. Like the appellants, it's Pivot's clients that are the people affected by this particular law. I propose to do only one thing in my 5 minutes today. And in my factum, I appended a list of over 100 reported decisions from British Columbia in which this sentencing judge exercised his or her discretion to find the surcharge payable forthwith and impose imprisonment in default of payment. What I propose to do is assist this court in understanding why an entire province of sentencing judges would exercise their discretion this way. The first factor I'll address is civil enforcement. So the courts below Tinker, the Ontario Court of Appeals, started with this in paragraph 1. They say, civil enforcement such as wage garnishment, asset seizure, income assistance set-off is not available with respect to surcharge debt because section 7379, which is the enforcement provision my friends took you to, does not incorporate 734.6. Unfortunately for Pivot's clients, this interpretation is mistaken. 734.6 merely provides attorneys general with an additional enforcement tool not available to private debtors. 734.6 reads, in addition to any method provided by law for recovering the fine, the attorneys general may register the debt as a civil judgment. Both courts found in my submission, a determinative factor that civil enforcement was not available for the surcharge. The fact that 737 doesn't incorporate this provision in no way stops provinces from like British Columbia from utilizing their own legislation, and BC does. We have the Financial Administration Act, it's my factum, we have the Land Title Act, we have the Employment and Assistance Act. We also have a decision from the BC Provincial Court, also in my factum, called RV Barroncut. And in that decision, the Provincial Court summarized the evidence of what they call a compliance officer, which is a provincial officer who's tasked with enforcing civilly, recovering the surcharge debt. The compliance officer, this is at paragraph 13 at Barroncourt, says, we garnish wages, we seize assets, we set off funds that come from social safety net guarantees.
These for provincial offenses or for criminal code offenses?
Criminal code.
Anybody ever taken a run at this?
I'm doing so now, sir.
Quite the same.
The issue is that both courts of appeal fundamentally misinterpreted section 7379. They say because it doesn't include this additional tool, there can't be any civil enforcement.
Practically speaking, even if in BC you have such a legislation, practically speaking, somebody who is not able to pay a surcharge, I would be very surprised if that person would have assets, or because we are saying that it applies to a very specific class of people, indigent people.
But it also applies to, it's the offset. Yeah. It's the income assistance offset. People in BC at the lowest level make $300 a month.
And the legislation provides that there could be an offset.
Yes. They can set it off, as well as garnish wages that are in your bank account.
The province is in the business of collecting surcharges that are imposed in a criminal context. Is this a new form of cooperative federalism, or what is this?
Well, Justice Moldaver, why wouldn't the province do what they're entitled to do? If someone has a debt owing to the province, and the province has debt collection mechanisms, why wouldn't they utilize the mechanisms that are available to them? They're not prohibited from doing so by the criminal code.
But they cannot send somebody to jail because the person is not paying the debt after a civil recourse.
Well, what I'm here to explain is why the judges exercise their discretion to send people to jail. I'm not here to justify that practice.
Okay.
The second factor, my friends have ably explained the consequences of the liberty issues that are engaged. I want to add one more, In 2017, in response to BC's opioid epidemic, Parliament passed unanimously the Good Samaritan Drug Overdose Act, which provided some protection for people who called 911 at the scene of an overdose. In the House, Conservative MP Michael Cooper responded to the question, well, why wouldn't someone just call 911? He said as follows, the simple answer is that far too often they are afraid. They are afraid of being charged with a crime. They are afraid of being caught up in the criminal justice system, so they do not call. They do not act, and the consequences of inaction can be fatal. In my submission, the same logic applies to the surcharge. Justice Pachoco said, if someone's threatened with arrest, they're liable to find that threat effective. This court has...
I would ask you to conclude.
Sorry, I'll just say this court has recognized in Bedford and in Insight that fear of arrest leads to many issues beyond failure to call 911. For a woman engaged in sex work, it's the failure to call police in the face of imminent violence. For a person experiencing homelessness, it's the failure to engage health services. And for all residents, it means reduced access to care